So let me just quickly start over. Professor J.J. Moreso is a professor of legal philosophy at the Pompeu Fabra University. He has a law degree from the University of Barcelona and a PhD in law from the Autonomous University of Barcelona. Before his current post, he has been a professor at the Autonomous University of Barcelona and at the Girona University. He has also served as a rector for the Pompeu Fabra University between 2005 and 2013. He's known for his contributions in the fields of the structure and the dynamics of legal systems, the theory of inclusive legal positivism, and the application of deontic logic to the theory of law and legal systems. His recent research focuses on the philosophical foundations of the Constitution. Now, the format of today is going to be as follows. I will yield the floor to Professor Moreso for 40 minutes. He'll be making his presentation. Then I have the honor of commenting on the paper for 15 minutes, after which I will yield the floor back to Professor Moreso for his replies. And eventually we will open the floor for questions and discussions at the end. So Professor Moreso, if you are ready, I will put your presentation up and yield the floor.
Thank you very much. Thank you very much. I am very, very thankful to the Turkish Association of Philosophy for this invitation to participate in these seminars. I am very happy with that, and I am especially thankful with to Professor Berkol Golgish, our acquaintance, may be possible to my participation today at this seminar. The seminar is I make a presentation while Yaya is trying to put the this is here, yeah. And my session today is on one aspect of the philosophy, very relevant aspect of the philosophy of Joseph Raz. Joseph Raz was one of the most relevant legal philosophers, legal and political, and moral and political philosophers in the during the last years. That unfortunately he died in 1 years and a half ago, and was very important. Was professor in Oxford for a lot of years, even in Columbia University in US. And my presentation is in fact devoted to one aspect of his account to the place of rules, of norms, of legal norms, more concretely of legal norms, the practical reasoning. That's a very important contribution. And exactly, this is the title, on the scope of exclusion of the notion of reasons of Joseph Raz. Well, we could pass to the other screen. Well, one explanation to begin. One explanation, very brief. In fact, the contribution, perhaps the most relevant contribution to legal philosophy and practical philosophy of Joseph Raz is his idea of norms, a reason for action, and exactly and precisely how norms represent how Raz called protected reasons. And I'll try to explain this contribution. I'll try to put certain doubts about one aspect of these reasons for norms as protected reasons for action, exactly about the scope of this exclusionary force of the reasons. I'll explain a continuation. But we could pass to the other at the beginning. Joseph Russ said in a seminar years ago, in a seminar of his work, said one very relevant statement, saying that our understanding of law is greatly defective unless it includes and it is based on a sound view of the role of law in practical reason. The first precept of legal theory is that law is practical, that its essential function is to play a role in its subject reasoning about what to do. And this contribution is devoted to trying to show the originality, depth, and farsightedness of his conception, especially his idea that legal rules provide us with protected reasons to act, that is, first-order reasons to behave as they prescribe, and second-order reasons not to act for reasons against what is prescribed. And this at the beginning, I'll try to put this very noun position in the legal philosophy nowadays, but in the other screen, I am able to put some ideas about the conception of Ras. Ras presents his idea as a critique of the common view we call, say, the orthodox conception of reasons for action. When, for example, I ask myself whether I should spend this afternoon finishing this article, this paper, or visiting a friend, or going to the movies, or what percentage of my Saturday morning shopping I should add as my contribution to the collection for the food bank, for instance, it's usual to consider that the structure of my reasoning is articulated by assigning a certain weight to the various alternatives according to the reasons that support them, and to decide in favor of the balance of action has the strongest, most powerful reasons, the reasons that decide the matter in a particular direction. This is the balance of reasons. We could pass to the other. And this is the model of the balance or weighting of reasons. Ras formulate this position in this way. It's always the case that one ought, all things considered, to do whatever one ought to do on the balance of reasons. This is very intuitive in the sense that we assign certain weight to one possibility, certain weight to another possibility, certain weight to the third possibility, and we decide in favor of the possibility, the alternative having more weight, This is the position. But Ras, and this is a very original contribution of Ras considers this is an incomplete principle to account for our practical reason. For example, if I promise my daughter to take her to a Katya Bunyatishvili concert, then my promise is a first-order reason to take her, and is not a first-order reason. It's also an exclusionary, a second-order reason to act for reasons other than the content of the premise. If on the day of the concert, for instance, I feel more like going to play paddle tennis with certain friends, or to go to movies or something like that, that reason should not be balanced with the reason for going to the concert, because that reason is excluded by my promise. This function of the promises in the practical reason. That is to say, reasons are structured on different levels, and that represents the necessity to reformulate, to limiting, to hedge this first principle through another principle, the principle two, and Raz said one ought not to act on the balance of reasons if the reasons tipping in the balance are excluded by an undefeated exclusionary reason. This is the point. This is the point. My preference in order to go to movies this evening is excluded if I have promised my daughter to take her to a concert, in a concert. And this represents this entails the necessity to reformulate P1 and pass to P3, saying is that one ought, all things considered, to act for an undefeated reason. This is the point. This is clear. This is the conception. And this is related, we could pass to another screen. This is related to the norms provided by legal norms, reasons provided, by legal norms used by authorities. I mean that norms in this sense work similarly to promises. This is the point of Raz. Norms, legal norms provide, according to Raz, protected reasons to act, reasons to behave as the norm prescribes, and reasons for one hand, and reasons that exclude at least some of the others' considerations for acting. Thus, it is possible to argue that law claims authority, claims the norms peremptorily bind. When such authority is legitimate, and it is when it meets the requirements of the doctrine of the so-called authority as service, then its norms reflect the underlying reasons we have for acting and achieve their purpose. This is the way in which Raz vindicates legal positivism. In order to be able to exercise their function as protected reasons, their identification must be possible only by attending to their social sources, without resorting to moral argumentation. The moral argumentation comes before, comes in the level of underlying reasons, but in the level of identification of reasons, I need only the social sources. We could pass to the other. And when the authority is legitimate, when the authority can introduce the reasons for action, because for us, not always authorities are able to put reasons, valid reasons for action. Because distinguishes for us and everyone, distinguishes between authority de facto and authority de jure or legitimate authority, even if for us authority de facto as a definitional trait always claims legitimate authority, but fails. This is the idea of de facto authorities. But the legitimate authorities, and this is the conception of the authorities as service, should meet the following three theses, very important in the theory of authority of Raz. The thesis one, this is the dependence thesis, according to which all authoritative directives should be based, among other factors, on reasons which apply to the subjects of those directives and which bear on circumstances covered by the directives. Such reasons I shall call, said Raz, dependent reasons. That means the authority is legitimate when the norms promulgated by authorities reflect the dependent reasons. The dependent reasons are the underlying reasons, and for us, clearly, these dependent reasons are moral reasons. This is the point. The second, all these partially are moral reasons, and the grounding are moral reasons. The second thesis is the normal justification thesis, and the normal justification thesis, this thesis contains the justification of the authority for us. The normal and primary way to establish that a person should be acknowledged to have authority over another person involves showing that the alleged subject is likely better to comply with reason which apply to him if he accepts the directives of the alleged authority as authoritatively binding and tries to follow them, than if he tries to follow the reasons which apply to him directly. This means, in order to comply with our dependent reasons of our underlying moral reasons, we should our behavior should be in accordance with the norms of authority, because normally this will be a better way to comply with the reasons. This is the idea. This is the normal justification thesis. And the three theses, and related to the idea of the exclusionary character of the reasons, is called the preemption thesis, and said that the fact that an authority requires performance of an action is a reason for its performance, which is not to be added to all other relevant reasons when assessing what should replace some of them. This is the capacity of substituting, of replacing the other reasons is even in the core, in the part and parcel of the idea of legitimate authority, of the idea of exclusionary reasons. We could pass. Well, Raz, and this is important to clarify this aspect. Raz is not thinking that legitimate authority, I said before, legitimate authority is totally independent of morality. In the last resort, is morality which justify authority, but in this special way, and for the reason Raz, clarifying his position, said, all I am saying is that when it is assumed that any legal system is legitimate and binding, that it does impose the duties it purports to impose. And I will generally proceed in this discussion on the assumption that the legal systems we are considering enjoy such legitimacy, because if not, there is no these conclusions. In such cases, we cannot separate law from morality as two independent normative points of view. For the legal, one derives what validity it has from morality. This is very important in order to grasp exactly the position of us. We could pass. Pass, please. Well, we are now with the problem. Well, Raz said that norms, legal norms as protected reasons have this exclusionary force. But he adds that legal norms as protected reasons exclude considerations which are included in the scope of the exclusionary reasons. And my contribution, my session is about this idea of a scope of exclusionary reasons. I mean, for us, exclusionary reasons have an scope, and that means that not all the considerations and all the first order reasons are excluded by exclusionary reasons. Only some of these considerations. And for the reasons, it's very important to determine which is the scope of these exclusionary reasons, because if not, we are not able to understand the way of operating reasons in the practical reasoning. And for the reasons, and for this motive, this produced one problem of interpretation in the RAS theory, one problem underlined by certain authors at the beginning for James Gans, and after this Spanish legal philosopher Juan Carlos Bayón, and one very, very good and recent contribution in a book in Oxford University Press for Gore. Bayón said, I take Bayón, but Bayón said exactly this idea in this way. The notion of the scope of exclusionary reasons seems to me that Bayón to be of the utmost importance, especially insofar as it represents a crack, said Bayón, in RAS construction through which an argument aimed at its global contestation can penetrate. I find it especially significant that RAS never explicitly clarifies how the greater or lesser scope of an exclusionary reason is determined, referring to norms which, as we know, are for us exclusionary reasons. Here used that while the presence of a norm does not automatically settle practical problems, because there may be other conflicting reasons not excluded by the norm, falling outside its scope as an exclusionary reason. It can nevertheless be said that, for the most part, the presence of a norm is decisive, since the conflicting reasons, they are in most cases excluded. And Bayón adds, but without an explanation of what determines the scope of the exclusionary reasons, these assertions are completely unsubstantiated. And I think that it's very important. It's very important. And moreover, if it's not possible, and that is my crucial suggestion, if it is not possible to determine the scope of exclusionary reasons, balancing the first order reasons, we have a problem, because we have also in the orthodox position again. Gore said, in my opinion, rightly, the weight of reasons is the one thing that the scope of exclusion cannot depend on, because if depend on that, the conception is not plausible. It's not plausible because I don't know, is not making a difference in our position. Well, we could pass to the other. Well, in another way, the problem is as follows. Legal rules provide us with exclusionary reasons to act when they reflect, according to the dependent thesis, the underlying reasons that the addressees of the rules have for behaving in that way. And according to the thesis of normal justification, if following what is established by the rules will probably conform better to those underlying reasons than following by our judgment, then those reasons will behave as a replacement reasons in the reasoning of data, according to the third thesis of quality-dependent thesis. Now, the replacement function of reasons is not absolute. Ras recognized that the reasons exclude only in some situations some of the underlying reasons. This is the question. Well, now I'll try to show that the Ras doctrine is not able to introduce to construct a criterion to delimit the scope of the exclusionary reasons, and I'll try to show that in a double way. Firstly, I'll try to show that Ras is not able to show the criterion of delimiting the scope of exclusionary reasons, understanding the reasons as directed, as addressed to the judges, to the application organs of law, as addressees, and after compare, I try to show that is unable to show that these reasons are exclusionary reasons. We have a criterion to delimit the scope of exclusionary reason as addressed to private citizens. Well, I'll try to show that in the following screen in order to reflect on the legal norms as addressed to judges, to application organs of law. It seems, it might be thought that the way in which legal norms are introduced into judicial reasoning is the way of superseding reasons. That is, legal norms block access to the underlying reasons, and that justifies judges more reasoning being opaque to them. But unfortunately, this is, in my view, this is not the point of Ras. I mean, if Ras is right, then we could understand very well the role of legal norms, because judges, in order to find out their duties, their legal duties applying the law, only they should resort to the rules, to the established by rules without resorting to the underlying reasons. And if this was in this way, this is no problem, and the judges accomplish the law according to the doctrine of authority of Ras and according to the nature of exclusionary reasons of the legal norms. But Ras said, for instance, when law uses moral considerations, then it defers to the discretion of judges, and said, for instance, this is a consequence of the fact that by the sources thesis, courts have discretion when required to apply moral consideration. And this is problematic, and I'll try to show the before getting to the application of precedents by judges in the common law world, and second, to the jurisdictional control of constitutionality, the judicial review present in many legal systems systems as we well know. Well, regarding the former, according to the common law question, Raz argues in the book The Authority of Law that judges in the common law sphere when apply precedents by virtue of distinguishing and overruling activities, that the most important and distinctive mechanism of applying by judges in the common law, have respectively the function of modifying and creating new law. Raz said, for example, distinguishing and overruling are the two kinds of powers to change existing common law rules which the courts have. And this is very important. And the second argue in the case of judicial review as follows. Judicial review not only makes the block to the exclusion or modification of constitutionally protected moral considerations by legislation enforceable. In addition, in conferring on the court's powers to enforce that block, it gives them, when adjudicating on the compatibility of legislation with the constitutionally protected moral considerations, the power to modify the application of those moral considerations themselves. So a second use of so-called incorporation of morality into law is to allocate powers among lawmaking institutions. Well, pass. Then what's the problem? What's the problem with this solution by Raz's concept of the adjudication of law in Raz theory? How can judges carry out this activity without resorting to the underlying reasons? It seems difficult, in my opinion. And it seems so because, for example, in order to know whether a specific new case, it is necessary to make a distinction in the sense of distinguishing, to consider a new property relevant, which the precedent to be followed did not consider, it is necessary to resort to the reasons underlying the fact of having the precedent available to us. I mean, in this case, it's clear that precedent is clear in my view, that precedent does not work the precedent as a protective reason, because the protection disappears. The protection disappears in the moment that judges produce distinction, the protection disappears. And when the protection disappears, because now one new property is relevant, and now the protection disappears, and now there are consequently considerations are not excluded by the precedent. Or perhaps better, let's see with a case referring to the judicial review to find out if thank you. To find out is an example of a Spanish system, a Spanish legal system, and discussed in Spain. To find out if burning the Spanish flag, crime of flag desecration, and our criminal code, this is a crime clearly in the sense that is introduced, is included in our criminal code, but in order to find out if this crime violates the freedom of expression constitutionally recognized in our constitution, like certain constitutionalists and lawyers in general defend in Spain, and this is very complex, and this is very complex even in front of the decisions of the European Court of Human Rights and so on. I said, it seems that it is necessary to go to the underlying reasons that found the granting of the right, and we cannot delimit the scope of the reasons excluded by the criminal code with weighing them with what is established by the Constitution. it seems difficult to determine if whether or not criminal code in Spain through the crime of flag desecration violates or not the Spanish Constitution and freedom of speech without I don't know, without analyzing, considering the reasons, underlying reasons in favor of protect our national symbols and so on, and underlying reasons protecting freedom of speech. That's very difficult. Well, we can pass now. Another example that's interesting in my debate with Yaya in order to determine that, sometimes Raz has considered in this problem, in this kind of problems, also the role played by the justificatory defense in criminal law. And said that these justificatory defenses in criminal law provide reasons that justify disobedience in the sense that apparently guilty homicide is kill another person should not be punished by law. Let us see how a Razian such as John Garner explained the functioning of these justificatory defenses, supported by the Razian idea that some legal permissions function as second orders that cancel the force of the exclusionary reasons for not acting for some first order reasons. In the example of self-defense, that given certain conditions, we can act by doing less than the prohibition to kill. This is the explanation of Garner. The idea is justifications in criminal law are in this terminology, Garner and Raz, canceling permissions. And canceling permissions means permissions that countervail the force of exclusionary reasons. Introduce considerations that now we could consider, but we couldn't consider if the criminal prohibition has the exclusionary force, and they retire. We can give up the exclusionary reasons of these prohibitions, and for the reasons is permitted. No, I agree. We can pass. I agree with that. But my point is, it's possible to determine if in one case it's or not the force of legitimate defense, for instance, self-defense, for instance, is able to block the exclusionary force. It's possible to determine that without balancing of reasons, without determining if this action is proportional, is legitimate, and so on. This is also determine the weight of underlying reasons. This is my point. And my conclusion is that foregoing cast many doubts on in what sense the reasons provided by legal norms can be conceived as preempting reasons when they are addressed to judges. However, perhaps the conception could be maintained for legal norms as addressed to citizens. And now we are going to this point. In a suggestive work, another legal Cohen elaborating certain ideas of Jeremy Bentham, invites us to the following mental experiment, Gedanken experiment. Imagine that we can establish a total separation between judges and ordinary citizens, and that while the former are governed by a set of rules, decision rules, different from the rules addressed to the latter, conduct rules. Citizens are governed by one rule, for instance, that prohibits killing, another that obliges them to fulfill contracts, another that prescribes them to stop at red lights, for instance. But judges in their chamber acoustically, as this is the acoustically cut off from citizens, have other rules at their disposal. For example, the rule that states that they should not punish those who kill in self-defense, the rule that allows not enforcing contracts granted by mistake or under intimidation, for instance, or threat. The rule that allows running a red light to take a woman about to give birth to the hospital, and so on. But these rules are not directed, are not addressed to the citizens, are addressed only to the judges. This is the idea. And perhaps in this way, we could understand that, and we could understand the idea of selling permissions of Razian, because canceling permission means that judges can open the prohibition in these cases. Well, pass to the other. That's the problem with this position. I do not consider that this is a good idea from a normative point of view. The acoustic account, the separate rules for citizens and rules for authorities. But it's the same. It's the same. Even if we consider that one explanation, I think that is not able to solve the problems of the idea of the scope of exclusionary reasons in RAS. First, because not all authorities are legitimate. Not all authorities in RAS comply with the three theses of the conception of authority as service. As RAS said, the thesis that authoritative reasons are not in addition to the other relevant reasons about what we ought to do, but replace some of them, is a thesis that should remember, and this is textual, literal authorities. It is relevant for the explanation of the character of de facto authorities, because every de facto authorities either claims or is acknowledged by others to be a legitimate authority. Well, but, said Raz, since not every authority is legitimate, not every authority directive is a reason for action. This is a very strong declaration. There are directives of authorities that are not able to provide reasons for action. This is very important. And if this is so, then citizens must determine whether or not the authorities are legitimate, whether the directives reflect the reasons we already have for behaving in a certain way, and above all, whether our behavior will normally be more likely to conform to these underlying reasons if we follow the directives than if we do not. And I do not see how then private citizens can, in their reason, determine whether the authorities' reasons supersede the first order reasons without turning to the underlying reasons, which are not excluded, at least for determining whether or not the authorities are legitimate. Surely, in order to determine if the authorities are legitimate, in my view, it's not possible to make that without resorting to the balance of reasons, to the reasons of first order reasons. We pass, but the second argument, let us suppose that we are dealing with legitimate authorities. Even in this case, and this is the second reason why citizens cannot turn to the underlying reasons. Even towards legitimate authorities, that there is, according to Raz, no duty obedience. And there is not, because legal authorities, even those belonging to reasonable just states, claim an authority that is more extensive than that which the thesis of dependence and normal justification protect. On the other hand, the normal justification thesis laws, RAS, says maximum flexibility, this RAS in the reflection of the morality of freedom, maximum flexibility in determining the scope of authority. It all depends on the person over whom authority is supposed to be exercised, strength of will, his reliability in various aspects of life, and on the government in question. And he adds, an expert pharmacologist may not be subject to the authority of the government in matters of the safety of the drugs. An inhabitant of a little village by a river may not be subject to its authority in matters of navigation and conservation, the river by the banks of which he has spent all his life. We pass on to the other. However, then legal norms do not operate in these cases as protected reasons. Thus, for us, as is well known, there is no general obligation, not even of facie, or to obey the law. Now, if the reasons provided by legal norms were always and all cases protected reasons, then there would be an obligation to obey the legitimate authorities. If there is not, it's because the scope of exclusion that the reasons endowed with authority claim to have is broader than what they really have. But in order to threat, we'll have not resort to the balance. We have to resort, to the balance of reasons. This is my conclusion. This is the most important, but two things more. One is, and then, which is the sense of the Razian thesis, which is the force of the Razian thesis about that. Well, I consider that the thesis, social sources thesis, the thesis in accordance with the content and the existence and content of law, said Raz, can be established, can be determined only resorting to social sources without resorting to moral argument, has not a metaphysical character. On the contrary, an epistemic character. The idea other scholars has defended. In which sense? In the sense that for us, he's considering that in order to establish the content of our obligations or our legal obligations, we should find out this obligation resorting only on social sources. This is my interpretation. But if we have the problem of the scope of exclusionary reasons, then somewhat ironically, we could ask about the for who is the exclusionary character of law, and perhaps is not for judges, is neither for judges nor for ordinary citizens, but perhaps is only for legal theorists, but is in an irony. And I pass to the conclusion. My conclusion is, if legal rules do not provide exclusionary reasons in practical reasoning, how do they operate? one could conjecture that legal rules activate three circumstances, the underlying reasons for behaving in a certain way, often going so far as to manipulate the reasons we already have and modify them in that way. This is what is known as the triggering reasons conception. The idea could be complemented by a conception as Mark Greenberg's, for instance, for which the content of law is the impact that legal institutions exert in the appropriate way on our moral profile. Although, as must be clear, determine how and to what extent the norms that proceed from institutions impact on our moral duties is crucial. My idea, and I am not sure in which extent compatible with Raz, my idea is that using a Rawlsian idea to relate the ideas of just justice and the good for another question, whereas institutions draw the framework of our legal reasoning, put the hedges of our legal reasoning, morality, that it is the underlying reasons, reveals its point. We pass to finish total. No, to finish here. I finished. Legal reasoning is, in my view, a kind of practical reasoning. It is practical because it is founded on and integrated into the practical reasons that affect us all. It is special because it's bounded by of institutional hedges. Both of these ideas are in accordance with Ras contribution, without which we could not have arrived where we are now. Nevertheless, the institutional hedges perhaps do not work the way of exclusionary reasons, as pretends, as claim. They work, in my view, as defeaters, as channels, gargoyles, which in the way institutionally established can be used sometimes for the citizens, sometimes for the applying organs, in order to resort to the underlying reasons superseding the rules. My picture in this sense of the law is an union of rules and underlying reasons too. And now, thank you very much. This is Ras and this is Gargoyles. Thank you.
Thank you very much, Professor, for this amazing presentation. Now, I will proceed with mine. Just a second. Now, actually, I can start with some general explanations while I'm opening the presentation. Now, I will just make some general remarks on whether we have any clues regarding the scope of exclusionary reasons in Raz's account, and then go on to my humble objections, one of which is, in my opinion, kind of conclusive, but the other one is kind of a word of caution and not necessarily conclusive. So some general remarks, the conditions of exclusionary normative force, as I like to call it. Well, these are basically things that Professor Moreso touched upon generally, so I will not take any time on them. I will just stress that the first important condition for qualifying as a legitimate authority, therefore, for legal directive to have exclusionary normative force, is the test of de facto authority, we could call it, meaning that only practical de facto authorities could be legitimate in the Razian sense. I find that interesting, so I just would like to stress that. The second one is the test of dependence, as also explained by Professor Moreso. It basically says that evaluations of the de facto authority must take into consideration those reasons that apply to the addressee, to the agent. Otherwise, if there are other reasons being considered, the end result, which is a legal directive, would not have exclusionary force. However, this is not an absolute matter. Raz mentions that there are some cases where, in order to serve the agent better, the authority will have to take into consideration reasons that do not actually apply to the agent. It's kind of it's really vague what these kind of conditions are. Raz does not elaborate these cases, but we should be aware that there might be uh, uh, some exceptions to this test. Lastly, we have the test of normal justification, which basically says that it must be the case that the agent is more likely to conform to her reasons if she followed the legal directive blindly or without any further considerations, rather than her own practical deliberation regarding the first order reasons that she has. Now, and from the literature, Razian literature, I tried to infer some limits on the scope of exclusion or some signs as to what kind of restrictions we might come up with. And the first is, this is something that Raz explicitly mentions, there are some personal cases, some personal issues regarding which it is completely improper that somebody else issues a directive and the agent follows that directive. For example, medical treatment is one example that comes to mind. Regarding the administering of a certain drug, the patient, the agent, has the only authority to evaluate the reasons that are applicable and to come up with a decision, although it may be possible, and that would be the epistemological authority, right? So advice could be taken, but it is important that the patient gives her own decision. The second, I believe, that the dependence thesis, while also constituting the condition for exclusion normative force, could also serve as kind of a restriction on the scope. And here is how I try to argue. Now, since a legal directive has exclusion normative force only if it takes into evaluation those reasons that apply to the agent. Reasons, the first order reasons that apply to the agent but are not taken into consideration by the authority could be said to be left out of the scope of exclusion. But this is not like a very clear matter. It's very controversial because it depends on your view regarding whether this is a mistake and also whether it's a clear mistake that the authority failed to take into account an obvious first order reason for action, whether it's a gray mistake. There's all kinds of discussion that I cannot go into detail in my presentation, but I've written about in my paper. So basically, I think that this is a clear mistake and that it should mean that such first order reasons are not excluded by the legal directive. So they are still there to be acted on. Lastly, I also think that normal justification thesis serves as a restriction on the scope of exclusion. Now, normally, and this is something that Professor Moreso also stressed, if I'm not imagining things, normally legal directives, even when they have exclusion normative force, their force is kind of patchwork, as stressed by Emran Mian, meaning that they might have this exclusionary force with regard to some agents while not with regard to other agents. And this is simply because let's assume that some agents are more expert than the authority concerning certain issues. So the legal directive would not have exclusionary force with regard to those agents. But then with regard to the same agent, there may be first order reasons concerning an issue on which the agent is more expert, and then maybe some other kinds of first order reasons on which the authority is more expert. That I believe that at least in the first observation, it could be argued that certain first order reasons are not excluded by the authoritative directive. Expert is the agent is more expert to evaluate those kind of first order reasons. But these are only suggestions and that they do not necessarily affect what is about to come. But one important thing to stress and one important difference of opinion between Professor Moreso and me is that I do believe that it is possible to characterize an authority as the legitimate authority without having to undergo the balance of first order reasons. And I have simple reasons for that. Whether or not dependence thesis, the test of dependence has been passed is obviously not an issue of balancing first order reasons. So you could simply have a look at what kind of reasons have been evaluated, if they are of course, epistemically available. Lastly, and this is the important part, whether an authority is the expert regarding a certain issue. And this is something that I discussed. I had the opportunity of discussing face to face with Joseph Raz. I was convinced by his answer. I'm not sure if everyone is going to be. It's me that there are like many cases where we decide that someone is the expert or more expert than we are, without having to look at the underlying reasons and how they evaluated them, whether they were successful. And obvious cases concern, for example, if someone is a medical doctor and if they have some kind of diploma from the university, I obviously can claim that they are the expert without having to see if they apply the correct treatment, so on and so forth. So it is possible for the political authority to be the expert regarding certain issues in a clear fashion. Although Raz admits that this is not going to be often. Like often, it is going to be the case that the authority will fail to be legitimate. Now I will move on with my first kind of objection. This is a kind of objection because it is not conclusive, and it can be demonstrated that it fails. Well, there are other cases where Professor Moreso's argument applies. It's a side issue, and it concerns the exclusionary force, legal directives, and the addressees of the legal directives. The fundamental claim is what I call the claim one, which is, I think, will be agreed upon by almost anyone. So only a legal directive addressing the force with that agent. Now, I think this is important, not because it forces us to reject Professor Morris's argument altogether, but it demonstrates that certain examples needs to be modified. For example, let's take the example with the Spanish case of unconstitutionality. So basically, we have a code like Spanish Criminal Code article, which criminalizes the burning of the Spanish flag. And then we have Article 20 of the Constitution, which protects the freedom of expression. And the argument is that to decide if the statute is unconstitutional, the Constitutional Court will have to resort to the underlying reasons and balance them against each other. So I will not challenge that view at the moment. Let's assume that resorting to the balance is necessary in this case. That, well, Article 5.3 of the Spanish Criminal Code, they are not legal directives addressing the Constitutional Court in this specific instance. It does not matter if the court has to or is able to resort to the underlying first order reasons. Because obviously, in my opinion at least, the Spanish Constitutional Court is the addressee of Article 161, which annuls unconstitutional statutes. So unless it is demonstrated that this constitutional court has to have recourse to the underlying reasons of Article 161, I think that the example fails to demonstrate the insufficiency of the account of exclusionary reasons in general. Now, this is inconclusive, my argument, because there is another example, and we will see that example in a second, which does not have this problem. So there we have to come up with another objection. I think this is the real objection to be considered against Professor Moreso's interpretation. Now, the core problem relies on the distinction between the consideration of first order reasons and the consideration of the balance thereof. Now, this time the example clearly addresses the same court, the criminal court, right? On one hand, we have a provision that prohibits killing of individuals, and on the other hand, we have the self-defense clause, let's call it for now. And the self-defense clause, let's assume further, that as follows. In cases where the initial attack is legitimate, the proportional reaction to that attack shall not be punished. So we might have several underlying reasons to have that kind of clause, and we might also have contrary considerations. And one consideration could be that the fact that a reaction was proportionate is a reason not to punish it. That's acceptable. That could be a first order reason to come up with such a self-defense clause. The other could be in cases where the initial attack is illegitimate, the reaction should not be punished. That's another first order reason. And it might be necessary that in order to determine if a certain act is within the scope of the self-defense clause, the court has to have to such first order reasons. Now, even there, you could argue that the recourse is not to the reasons themselves, but to certain concepts which are also mentioned by the expression of the reasons. But I will not go there. I will assume that it is a true recourse to reasons for action. Even there, having this recourse does not demonstrate that we have to balance them against something else, then come up with our own decision. At least I think that this is not demonstrated in the argument. And unless that is demonstrated, I don't think that the account of exclusion reason is under threat. Because as Joseph Raz stressed in his practical reason and norms towards the end of the book, exclusion reasons should not be considered as reasons to refrain from taking certain reasons into account or reasons to refrain from considering certain reasons. They are simply reasons not to act on those reasons. So even in this case where both norms that are under consideration address the criminal court, if the criminal court is certain first order reasons and whether the act has anything in common with those reasons, that should not be a problem for the account of exclusion reasons. What we must demonstrate, and I think this is, well, I humbly claim this is what is lacking in the argument, is we have to balance such reasons against each other in order to determine whether a certain act is proportionate or a certain certain assault is illegitimate. I don't think that this is necessary because these are simply concepts. But I'm ready to be corrected. Thank you very much for listening. So without taking any further of your time, I will yield the floor back to Professor Moreso. Thank you very much.
Thank you. If it's my turn to say something about that.
Yes, please, Professor. The floor is yours.
Yeah, thank you. I am very thankful for Yaya for these insightful comments. Really, in fact, this paper, this English version of this paper, is accepted for publishing for be published in Ratio Juris, and I dare to invite Yahya to consider to write and submit this criticism to Ratio Juris when my paper will be published. This is a good idea in order to discuss of that. Well, after all, the comments of Yaya are very able to grasp the crucial point of Raz, and also my criticism about the scope and the difference, because this is, and said Yaya with reason, that the distinction, my contribution perhaps underlies the distinction between legal norms as protected reason as addressed to judges and as addressed, on the other hand, to citizens is very important. Well, my reply of these objections are this way: as addressed to citizens, they determine whether some first order reasons are excluded or not. It's not necessary, said Yaya, to resort to the balance. It is sufficient to consider whether or not considered by authorities, and if they are considered, they are not considered, sorry, they are not excluded. If they are considered, given that the normal justification is met, then we do not need to go the first order reason. It's possible that Raz thought in this way, but in my paper, I do not consider the distinction now now stresses. The difference with the difference in RAS between clear and great mistakes. That's very important. That's RAS said, for instance, consider a long addition of, say, some 30 numbers. One can make a very small mistake, which is a very clear one, as when the sum, for instance, as an integer, whereas one and only one of the other numbers is a decimal fraction. And this is obviously, in this case, this is a great mistake. I agree with that. I agree with that. I agree with the idea that it's possible to detect great mistakes without resorting to underlying reasons. I agree. But in my view, this is not able to cover all the cases. There are other cases with mistakes, with important mistakes, and in this case, it's not possible to determine that only with these clearly mistakes. And my view, I insist, in order to determine whether the authority is legitimate or not, or even whether the authority is more expert than me on certain things, how I can determine that? I can determine that resorting to underlying reasons. And underlying reasons and balancing underlying reasons. Now, after I refer to that, because if not, it's not possible to determine that. That's my point. But perhaps it's more interesting to go to the norms as addressed to judges, because here the IS argument is judges can resort to underlying reasons in the case of norms which are not addressed to them, because there are norms not addressed to them. And in this sense, it seems that Yaya takes something like the acoustic account with an important variation, but the acoustic account in the sense that there are norms directed to judges and there are norms directed to citizens. I mean that canceling permissions like legitimate defense justification or fundamental rights are addressed to citizens and not to judges. But judges can determine the limitation of the scope of the criminal law prohibitions according to the balance of reasons, because these norms are not addressed to them. This is, to me, a quite odd observation. In fact, the attraction of the acoustic account lies on the idea that canceling permissions, as in Garner, for instance, are addressed only to judges, nor addressed to judges. In any case, canceling permissions can only be triggered when we are able to show that there are reasons not excluded by first order reasons. And this is an operation not attainable without balancing the first order reasons. Why balancing and not only, and it is not possible to avoid, to neglect the balancing? This is, it is right, totally right, that even in RAS, the operation of these exclusionary reasons is not the prohibition to consider the reasons, only do not act for the reasons. This is true. This is true. But my point is, for instance, criminal scholars said that justifications are applied using balancing, precisely. Legal rights are applied using balancing. It's not imaginable to me, not conceivable to me, how a judge can apply legitimate defense in a case, or can decide that certain criminal prohibition vulnerates a fundamental right without balancing, because this is intrinsic to the function of determining of, in this case, there is self-defense. On another case, there is a vulneration, a violation of a fundamental right, is necessary to balance. And this is perhaps the most important objection to the answer of Yaya in my view, is saying that precisely this beautiful example that consider, for instance, justification in criminal law as canceling permissions entails that for finding out whether or not this permission is able to cancel the force of exclusionary reasons is necessary to balance. That's my point, because it's intrinsic to the idea of canceling permissions in this way, applying these permissions, balancing. This is my point. Be that as it may, Yaya's comments are very relevant and led me to think more accurately some questions of my contribution. Thanks a lot, and I invite to consider to submit his contribution in order to follow to be continuing this debate. Thank you very much.
Thank you very much, Professor. Now that the whole process is finished, we are finally opening the floor for your questions and views and comments, if you have any. Anyone wishing to speak? If you can just, okay, yes, please, Professor Timothy Endicott, please.
Thank you very much.
Timothy.
Joseph, Jose Juan, it's really good to see you. Greetings.
Really good.
Greetings from Oxford. And I want to thank Yaya for inviting me to join this exciting session. I wish we were all in Istanbul. Thank you, Jose Juan. I just had some sort of observations or thoughts. And by the way, I find the Joseph Raz's account of rules there's something really attractive about it. Suppose there's a criminal prohibition on taking bribes by public officials. Well, so, and you offer me a bribe, and I think, well, on the one hand, that's 1,000 euros. That's receiving 1,000 euros. That's good. On the other hand, somebody says I'm not supposed to do that. Well, and of course they could come after me. They might catch me, and then they would fine me 10,000 euros. And so I'm thinking about all these considerations. And of course, if I treat the law as authoritative, I will say, oh, 1,000 euros, I love that, but I mustn't, because the law prohibits it. And then if you say, okay, I'll give you 2,000 euros or 100,000 euros, if I treat the law as authoritative, you're not even moving in the right direction because of the prohibition. So the more you offer me, the more valuable that consideration is, but I can't act on that consideration. So I find something quite attractive about it. But of course, there are other more complex relations between the underlying reasons and the supposedly exclusionary reason. And I do think it's really interesting what you pointed out, what Bayonne pointed out, that Joseph Raz never explained the scope. He just says At least some. An authoritative directive excludes at least some considerations. And I think that he was not, he wasn't, it's just that he hadn't really worked this out. I think it was really important that he couldn't give a theory that answers the question, which considerations are excluded and which are not. If you think, here's a simple example of authority. You're an 8-year-old child and your mother is going out to the shops and she says, Jose Juan, stay in the house while I'm gone. Now she's exercised authority and she's gone to the shops, and then your friend comes and knocks on the door and wants you to come out and play. Well, if you accept her authority, you know very well that there are considerations in favor of going out. It'll be fun. You'll get fresh air. You really like your friend. That'll be wonderful. But you cannot act on those considerations. And of course, Raz has an explanation why it might be true that it would be wrong to act on those considerations. Now, but suppose your same situation, your mother's out, and the house catches fire. The house is burning. The house is going to burn down. You're going to die too. And then if Jose Juan has respect for his mother's authority, he won't say, "Oh, I guess I have to burn to death because she has excluded action on other considerations." Well, that I suggest would be a very bad interpretation of your mother's act of authority, her directive to stay in the house. And Jose Juan can run out of the house and escape the fire, and there's no respect for his mother's authority, because, here's how I see it, she didn't exclude that consideration. Now, how do we know? Well, it's only because of an interpretation of her act of telling you to stay in the house. And there are really good reasons to interpret it as not excluding the action for the purpose of saving your life. And that's because of your relationship, because of who she is, and of course, very importantly, because of the justification for her authority. And if you treated her directive as absolute, excluding all considerations, then you would turn her own authority into a disaster, because she uses that authority for the purpose of a mother. And that explains why she can exclude going out of the house for fun. But it's not just that she didn't intend to tell you to burn to death. It's that she didn't, of course, she didn't even think of that. And to understand her authority, you have to understand it as used for good purposes. So there. Now, I think it's very clear that going out of the house, for the fun of going out of the house to play with a friend, is excluded. The emergency necessity of running out of the house to save your life is not excluded. And of course, this is a vague distinction. And I think all you can say in general is that her directive must be understood as excluding those considerations that must be excluded if she is to carry out her authority for the purposes for which she holds it. And there's a very vague distinction that's based on evaluative considerations as to the purpose of her authority. So, I mean, it's kind of ironic that a model that seems so rigorous and austere actually has in it this vague distinction between considerations that are excluded and are not excluded. So I wonder what you think about that, Jose Juan. Maybe there is a very important distinction between excluded and non-excluded considerations, and that defines the scope of her authority. But it's vague. I wonder what you think about that. And then I have some other comments, but I don't want to take all the time.
Oh, thank you very much, Timothy. Very nice to find here in surprisingly to me. Thank you very much. No, I strongly agree with you that it's very important to distinguish between excluded and considerations, and this is a point in favor of us. But perhaps my point is a very minor point, but it's a point about if we accept that there are non-excluded considerations, my point is this is very important in the law, and in the case of not excluded considerations, we do not have the force of exclusion of reasons, and we need again to resort to moral considerations, and then the position, the radical position of Raz about that the content of law is identified, should be identified only resorting to social sources, perhaps is not totally convincing, in the sense that in some cases what law requires is determined by this balancing, because there are non-excluded considerations which are relevant in this case. That's my point. In fact, Raz accept that in the case of judges, said only that in this case, judges have discretion and they modify it and create new law. But this is, you said that once the surprising part for us. This is the surprising part to me also. This is why in this case is only a question of discretion, and is modification and creation of law, and we cannot say that in these cases morality determine our legal obligations or our legal rights. That's my point, not the point. I agree. I insist that I agree totally agree with the idea that it's very important and very relevant to understand well the place of authority, distinguish between excluded and not excluded considerations. Thank you.
Thank you very much both for the answer and the question. Do we have any further questions? If not, maybe for now, welcome. If there are no further questions, maybe we should ask Tim to continue commenting.
Yeah,
No,
we may close if you want.
Okay. If there are no further questions, we will close it. Tim, would you like to continue commenting, or?
Oh, just one really quick thing on flag burning. I wonder if Raz would say if the Spanish criminal code prohibits burning the flag, then that's a legal rule. The law claims authority to require you not to burn the flag, and that's an exclusionary. There's an exclusionary reason that protects that prohibition, which is a purported exclusionary reason not to act on other considerations. But if a court has authority to hold that doing so is contrary to that the prohibition is unlawful because it's contrary to the right to freedom of expression. Well, if the court's approach to that jurisdiction is to use a proportionality test, then the court has discretion, discretion to cancel the obligation. And then that would be another surprise, you might say, another surprising result of Raz's theory. And by the way, in the common law, I think I think this follows from what you were saying, Jose Juan, that in Raz's theory, the higher courts, the appellate courts in a common law jurisdiction, have a discretion to change the law. So, and then it's as if we had a code of civil and criminal obligations, and a court that is authorized to depart from them. And then you might say, is that a legal system at all? If there's just a discretion to depart from the supposed rules, are they rules if there's a court with discretion to depart from them?
No, I see. Well, in Spain it is a bit more complicated. I explain in a way because the criminal judges and the criminal courts in Spain and in general the courts in Spain have no ability to disposition in the criminal prohibition in the criminal code because they consider it unconstitutional. They can only to put a question of constitutionality, this is the name, to our constitutional court, because this is the system of centralized control of constitutionality, and is the constitutional court able to decide. But the constitutional court, they decide that, I think, balancing the freedom of the values protecting the freedom of expression and the values protecting the protection of national symbols or something like that. And in Spanish legal culture, you know, different from common law jurisdictions, this is not usual to consider that in these cases constitutional court changed the law, because constitutional court is subjected to the constitution, and if constitutional court decided that this criminal prohibition is contrary to the freedom of expression, then the situation is that decided to declare void, null this prohibition, but this is because the Constitution prohibits that. This is a declaration of a nullity value, but this is a legal question. This is not so the question. I think that the most important question in my view is that the Constitutional Court only could decide that balancing. That's my observation. Thank you.
Thank you very much, Professor Moreso, Professor Trinity Andeket, Professor Güliz Uygur, and generally the Philosophical Society of Turkey. I think we are at the end of our event. Thank you all for participating. Would you like to say any final words, Güliz Hocam?
No, I would like to thank you, Professor Moreso, again, and then the other Professor Timothy and the court. If you say correctly, maybe I cannot pronounce your name correctly. Sorry. Thank you so much for your participation. And thank you also, Yahya, for organizing this event.
My pleasure.
Yes, thank you. Bye.
Thank you very much. Thank you.
Bye-bye. Thank you.
Thank you. You.